The broadcast is now starting. All attendees are in listen-only mode.
Yeah, you are good to go. Ed, you are live.
Okay, hi. Good afternoon, everybody. My name is Ed Delahanty, and I'm a UI Program Director, Assistant Director at the Troy Telephone Claims Center in Troy, New York. Currently, the way to file an unemployment claim is really, there's only two ways. In the old days, back before 1999, when telephone claim centers were established, the only way for a claimant to file a claim when they lost their job through no fault of their own was to go to a local office, which there were approximately 80 throughout the state, and a claimant who lived near that local office would pick the closest one to their home, physically drive to that office, and file a claim in person. Well, back in the late 90s, the federal government mandated New York State to open up call centers and to no longer just allow local office filing of claims. So we used to be bricks and mortar, and now we're much more of what we call a virtual office. The only way for claimants to file a claim would be to call into one of two call centers, and I said one of them is located here in Troy, New York, where I work. The other call center is located in Glendale, New York, which is outside of Binghamton. Each call center is staffed with approximately 400 people. We have folks who take initial claims, and then we have also my staff that I'm in charge of, which adjudicates claims. When a person files a claim for unemployment benefits, as long as there's no what we call issues, an issue would be if a person was separated from their employment. They either quit their job or they were discharged or fired from their job. That would raise an issue that my staff would have to adjudicate whether or not that person is eligible based on the reason that they separated from their employment. So just to go and give a little bit of basics on unemployment insurance. What is it? It's a temporary income funded by you, the employer, for eligible workers who become unemployed through no fault of their own. About 80% of all the claims that go through on a yearly basis are what we call clean claims. The claimant did truly lose their job due to a lack of work. There was not at any fault of their own, and there was no protest on the employer's behalf. Those claims go through, and the people start claiming benefits after a one-week waiting period. That one-week waiting period is in effect for all claimants. And basically, the way a person would qualify to receive unemployment benefits, they would have to lose their job due to a lack of work, or they could lose their job because of the fact they were fired, but it didn't rise to the level of misconduct, and I'll cover that later on in the presentation. They also must have a minimal amount of earnings. They have to have they must have earnings in at least 2 calendar quarters, and the highest quarter must be a minimum of $1,600, and the total base period wages must be 1.5 times the high quarter wages. So the minimum amount that someone would have to earn in what we call covered employment, employment that was reported to Tax and Finance, would have to be a minimum of $2,400 with at least $1,600 in 1 calendar quarter. If a person meets those minimum stipulations, they would qualify to, they would receive what we have entitlement. They would have entitlement to file a claim. If they don't meet those minimal qualifications, then they fail to meet entitlement parameters, and we would send them a letter basically informing that they don't have enough employment at this time to file a claim. And the base period, that's how we look at the base period. Is we go back almost 18 months and we look at what the employment history is for the person filing that claim. And the basic base period would be the first 4 of the last 5 completed quarters to the calendar in which the claim begins. And we also have an alternate base period. If a person doesn't qualify in the basic base period, we'll look at the first 4 completed quarters completed immediately filing a claim. This just gives an example, this slide, of what the base period is. If a person filed a claim this week, if they filed a claim today, Wednesday, June 20th, it would still be effective on Monday. It would be effective June 18th. And their base period would constitute the calendar year of 2011. And basically, because right now we're in the second quarter, the first 4 of the last 5 completed quarters would be the first quarter of 2011 through the fourth quarter of 2011. If we were to use the alternate base period, we would use the last 4 completed quarters, which would be the second quarter of 2011 through the first quarter of 2012. And this just gives you an example of how we determine what the base period is, and a claimant must meet those minimum stipulations that I mentioned on the slide before in order to have entitlement. If a claimant does not have entitlement, they don't have the minimum amount to file a claim, even if there was an issue, we would not even adjudicate that issue because there's really no reason to. They don't meet the basic entitlement requirements, so there's no reason to send them a determination as to whether they're eligible or not because of the fact they're monetarily not eligible. The maximum rate in New York State currently is $405, and the minimum rate per week is $64. Just as a little bit of background, the maximum rate of $405 has not changed since 1999, which is quite a period of time to go by without an increase in the unemployment rate. There are a lot of states that neighbor New York that have a much higher benefit rate. For example, Massachusetts has a maximum benefit rate pretty close to $700. And I know even New Hampshire and other neighboring, Connecticut, have much higher benefit rates than New York does. There is current legislation pending to increase the rate, but that's only a bill. It hasn't been signed into law, and it's still got a long ways to go. But it has been quite a while since New York State's maximum unemployment insurance benefit rate has had an increase. As I mentioned, I believe it was 1999 when the rate at the time went from $365 per week to $405. The way the unemployment rate is figured is we would take 1/26 of the high calendar quarter. So an example on this slide shows that a person who earned $10,530, if you divide that by 26, it comes up to $405. That would be the maximum benefit rate in New York. Anybody who earns less than $10,530 in their high calendar quarter would have a lower benefit rate than $405, and we would divide it by 1/26 to determine what that rate would be. If they have earnings that are underneath 3,000, underneath that number there or less, what we use is 1/25 of the high calendar quarter to determine that benefit rate. Now, although an unemployment insurance claim is open a year, we call it the benefit year. So if a person were to file a claim using the example I used today, and the claim was effective on Monday, June 18th, that claim would be valid until the following year, which would be the Friday of the following week, which would be June 22nd, 2013. That's what we would call their benefit year ending date. So a claimant basically can collect 26 weeks of unemployment benefits during that year. So if they receive all 26 right after they get laid off, and at the time there's no extended benefits or emergency unemployment compensation, that would really be it for the person. This enables people to actually work part-time and still keep their unemployment claim open. So in other words, if a person was working a day a week, they would actually declare that day a week. They would receive less on unemployment insurance because of the fact that they're supplementing it with employment, but they would be able to receive their unemployment insurance longer than the 26 weeks because of the fact they're stretching it over a longer period. I did want to mention a little bit about emergency unemployment compensation and extended benefits. These are federal programs, so you, the employer, do not fund any of the extended benefits currently. The employer is only really on the hook for the first 26 weeks of regular unemployment insurance. So any emergency unemployment compensation that a claimant may receive after they exhaust their 26 weeks, you, the employer, are not charged for any of those benefits. and that also applies to a different program, which is called the Extended Benefit Program, also a federal program. Currently, claimants could receive, depending on when they filed their claim, and there are really a lot of variables to this, but each claim would be different. But certain people could receive up to an additional 67 weeks of extended benefits, depending when they file the claim. But that also can change at any time, depending on the federal legislation. It's scheduled, the emergency unemployment compensation and extended benefits are supposed to sunset at the end of 2012 unless it's extended. So a lot of times Congress will extend it, but there's no guarantees on that. Okay, to qualify to receive unemployment benefits, one must be totally unemployed on any day that they're seeking credit. They must be ready, willing, and able to work. I was just briefly talking about if a person was working, it can actually extend the time that they receive unemployment benefits. So each day of work would reduce their unemployment payment by 1/4. So say a person has a $400 a week unemployment insurance benefit rate. If they work 2 days a week, we would reduce their benefit rate by half. So they would receive $200 in unemployment insurance for that week, plus whatever 2 days pay they receive for the work. Claimants also must be actively seeking work. And although we don't have the local offices where people used to file claims, we still do have a Division of Employment Workforce Solutions, and claimants are required to report to these offices. They're one-stop offices that are staffed by both state and county workers. And they'll help people to get them back reemployed. They'll help them with resume writing, job search workshops. They'll try to help them with a plan to just basically get them back to work. And it does affect their unemployment benefits if they do not report to these meetings because of the fact that the federal government also mandates that they report to these one-stops at least once during the time they're receiving unemployment. I want to talk about some issues that affect employers, and voluntary separation is under Section 593.1 of the New York State Unemployment Insurance Law. And basically, if a person works for you and quits, they are what we consider to be the moving party. They initiated the separation. So we're going to look at that as, did the person have what we call good cause to quit? New York State is considered to be a good cause state. Some states aren't. A good cause state means there's provisions in the law where a person could get paid for unemployment benefits after quitting if they quit for compelling reason. Some states don't have that. No matter what reason you quit, you're not eligible. But New York State does have in their law that there are considered compelling reasons to quit, which you could be found eligible. In 2009, Section 531 of the law was amended, and they actually included reasons which could be considered compelling, which would enable a person to receive benefits if they quit for one of these reasons. And fear for safety to yourself or other family members due to domestic violence is considered good cause to quit a job if a person is unfortunate enough to be in a situation like that. Also, if you follow a spouse who obtains employment outside of a reasonable commuting area, they could also be eligible. Also, if you're caring for a relative, that could also be another reason. So before I get into misconduct as when a person is discharged, in New York State, because we're considered a good cause state, if a person quits, we're going to ask them the reasons why they quit. You as the employer, you may not even know why they quit. Sometimes a person may not even give you notice. They just abandon their job and just stop showing up. You may not be able to give us much information on that separation, but if you do have any information when the department requests it, it would be great if you could share, such as a resignation letter or anything like that. Excuse me. Okay, I want to talk a little bit about misconduct. Misconduct is another issue that directly affects employers, and that's defined in Section 593 of the statute. The statute itself does not define what misconduct is, however. That's defined by our case law. And I did want to give people our website address. If you check our website, you can go into our employer page, and you can actually go in and look at our interpretation cases. And these are cases that our labor service representatives use to adjudicate claims. Our website is www.labor.ny.gov. And if you go in there and check out the employer webpage, you can actually go in and look at our precedent cases. And it kind of gives you an idea of what we use. What our precedent cases are cases that went to the Unemployment Insurance Appeal Board or above. Anytime a person is adversely affected by a determination that's issued by the Department of Labor, they do have a right to request a hearing on that determination, and it goes in front of an administrative law judge. I'm sure many of you folks may have attended an unemployment insurance hearing before. But basically, getting back to the issue of misconduct, when a person is discharged from your employ, certain things have to be present for us to make a determination that a claimant lost their job because their actions rose to the level of misconduct. So as I mentioned, misconduct is not defined in the statute itself. However, the Court of Appeals, which is the highest court in New York State, in the case called the matter of James, basically defined misconduct as any volitional act or omission which is detrimental to the employer's best interest. Well, the problem with that is it's a very gray statement. The law is very gray, and unfortunately, not everything is black and white. So we have to look at what exactly did the person do. Was it egregious enough to basically really not be in the employer's best interest? Now, for misconduct, for instance, attendance. We'll talk about attendance. One of the things that the Department of Labor looks for when we issue a determination is, did the employer follow progressive discipline? In other words, was the claimant made aware that their attendance was a problem and that they needed to improve it? Were there any warnings given? Were there any counseling memos written? Was there any other discipline taken? All of that would help your case, because a person needs to know that their job is in jeopardy and that whatever behavior is causing that job to be in jeopardy needs to change. If they're not made aware of that, then sometimes we can't issue a misconduct determination. Inefficiency, poor performance, inadvertent errors in judgment usually aren't considered to be misconduct, depending on the egregiousness of what they did. If someone walks out with a company pen by accident, even if it's a violation of a policy, is it misconduct? Probably not. They may have just, it was a poor error, or it was an error in judgment. But if a person walks out with a laptop, well, that might be a little bit different. So we have to look at, what exactly happened to cause the person to be discharged. If a person is trying their best, they're just making a lot of errors, it just didn't seem to be a good match, and you let them go, most likely that's not going to be considered misconduct for unemployment purposes. So it is very important that employers, when they do their screening process, they do it very thoroughly, and they vet all the candidates thoroughly, because if you hire them and they don't work out, they could be eligible for unemployment. Before I talk about refusal, which is another issue that employers have to deal with on a regular basis, we talked about ordinary negligence. If a person commits gross negligence, that can be considered misconduct. An example I use of gross negligence would be the bus driver that at the end of the day doesn't do a sweep of the bus and leaves a kid on the bus. And because the consequences could be dire, and really egregious, that would be considered gross negligence, and that person most likely would be disqualified for misconduct. It's not like they did it on purpose, but the mistake was egregious enough and the consequences dire enough that really it should result in a disqual. Another example could be an auto mechanic that changes the oil in a car and forgets to put the new oil in, and that engine burns out. That could also be gross negligence. All right, talking about refusal of employment, that basically says no days of unemployment will deem to have occurred on any day in which a claimant without good cause refuses an offer of employment for which he is reasonably fitted through training and experience. Refusal is actually defined in the law, which is section 593.2, and there's a lot of things that we have to look at with a refusal. What a refusal is, and it usually happens with a base period employer. And what that means is a base period employer, you're the employer are being charged on your account for benefits received from a claimant. When you have work available and you offer that work to a person who's receiving unemployment insurance, most likely if it meets certain criteria, they have to take that job, or it could result in a disqualification. The three issues that do result in what we call disqualifications, I've already mentioned, they're voluntary quit, misconduct, and refusal. And those are the three issues that employers deal with the most. The difference between a disqualification and just a suspension is that a disqualification, a person actually has to go back to work to requalify. So in other words, if you discharged a person who was fighting on the job or stealing from you, something that rises to the level of misconduct, if they file a claim, we're going to look at that claim, and we're going to say, well, wait a minute, their actions were egregious. They're not going to be eligible. But it could be someone that even got laid off through no fault of their own, and then all of a sudden you have work again. If you offer that person work and they don't take it, we're going to look at that as a refusal. So one of the things that would state that the refusal was with good cause, we wouldn't expect people to cross a picket line. So if it would interfere with union membership or a collective bargaining agreement, we wouldn't expect them to take that job. Or if there was a strike, lockout, or other industrial controversy in the establishment. Also, if the work offered is an unreasonable distance, and for unemployment purposes, we define unreasonable distance. We use public transportation. A person can be expected to travel up to an hour and a half. So for downstate residents who utilize the subway system and buses, they may be required to travel up to an hour and a half by public transportation. By private transportation, we look at up to an hour of travel. So if the job offered was more than an hour away by private transportation, the claimant could have good cause to refuse that job. And the biggest thing that we look at as far as refusals are the hours. We have what we call prevailing wage, and we use prevailing wage to determine whether or not the pay offered for the job meets prevailing wage. If the job pays within 10% of the prevailing wage for that location, a claimant is required to take that job. And you can check out prevailing wages once again on our website at www.labor.ny.gov. You punch in whatever the job occupation is. You'll pull up your county, and it'll show you the prevailing wage for that county. Basically, as I just mentioned, a refusal with good cause of offer, if the job pays more than 10% below the prevailing wage established based on the average wage of that area, the person would have good cause to refuse that job. And this slide just gives you an example of how we would determine prevailing wage. In this particular, say, fictional county, depending on what the occupation was, if the high wage in that area was $12 an hour and the low wage was $8, we're going to use the middle wage to establish prevailing wage. In this case, it would be $10 per hour. So a claimant would not have good cause to refuse any job at $9 an hour and up, because that would pay within 10% of the prevailing wage for that area. All right, a claimant does have to seek suitable work for which they're trained for, through which they're fitted for through training and experience, and work that pays within 10% of the prevailing wage for that locality. So we tell claimants that up front, they're made aware of that. Claimants can check the prevailing wages too, the prevailing wages on the website as well. If you do have work for the claimant, you don't necessarily have to make all of that information in the letter you send to them or the phone call you send to them. All you have to do is, and what we suggest is you send them a certified letter, because that gives you a record of the fact that you did send them a letter, and usually a certified letter someone has to sign for. So the more evidence that we have, that actually shows us that you've made a bona fide offer to the claimant, and that is one thing that we look at. And it usually does help it when you send a letter. A lot of bona fide offers are made over the telephone verbally, but we just always feel it's better if you have a letter in writing that was mailed to the claimant offering the job. Even if you offer them to come into a job interview and you never hear from them again, that could be tantamount to a refusal. So anything like that you know, let us know, and we're going to look into it. One of the big initiatives with the New York State Department of Labor right now, and it's really coming from the federal government, which funds 90% of the UI program, is integrity. So we take fraud very seriously, and if you know of anybody that's receiving unemployment benefits fraudulently, please let us know, because we do take that very, very seriously. After a claimant receives 13 weeks of benefits, the refusal issue changes a little bit. 13 weeks is the halfway point of an unemployment insurance claim, which lasts 26 weeks. So after a person has been on unemployment insurance for 13 weeks, after the 13 weeks is up, they are required to take anything that they're capable of, which is a little bit different than fitted for through training and experience. So after 13 weeks, they're held to a little bit higher of a standard. And the reason is that it's always better to work than it is to receive unemployment benefits. So if there's jobs out there that they're even capable of doing that they've never done before, but with a little bit of training they can do, as long as that job pays within 80% of their high calendar quarter, they're required to take that. But we still look at the prevailing wage, and that work still has to, the job offer still has to pay within 10% of the prevailing wage in that area. So that's just basically just some information that after 13 weeks, claimants are held to a little higher standard, and basically they have to accept anything that they're capable of doing, and really they should be out there looking for work. What about you, the employer? A lot of claimants, when we have them on the phone and we're trying to get information from them, or we've issued a disqualification to them, they sometimes will get angry and they'll say, well, I've paid into this my whole life. But that's not the case. They really haven't. The claimant does not pay anything for unemployment insurance. The whole bill is footed by you, the employer. So if you feel that this person who you just got what we call an LO 400, any person who files a claim, if you as an employer are in the claimant's base period, you're going to receive an LO 400. And what that LO 400 is, it's a notice of monetary entitlement and potential charges. So if a claimant meets the minimal monetary requirements that I talked about earlier, $2,400 with at least $1,600 in 1 quarter, they qualify monetarily, you're going to receive a letter that they filed a claim, and that letter is the LO 400. It's made up of 2 sections. Part 1 basically gives the effective date of the claim, the benefit year ending date, the total base period wages, what the benefit rate is, maximum allowed, wages paid by the employer, and the employer's potential charges. So when you get that, look it over and make sure that the wages that are being reported are correct. If those wages aren't correct, you're given an opportunity on the form to actually make those corrections. This is an example of what an LO400 looks like. The date on this is 2007, but the form does still look the same. And you can see here that it shows base period earnings, and the employer here did make a correction to the wages for the fourth quarter. They actually made that correction. And so if the wages that are being reported don't look correct, please let us know. It could affect what you're being charged. If the claimant earned less than what's being reported, you shouldn't be getting as charged as much. So you should let us know, and we'll make those corrections to the claimant's claim. Now, Part 2 of the LO400 is very important for the employer, and that's the area to comment on any reason that you may know why this person should not be paid. You may not know how the claimant told us their job ended. Many times a claimant will say their job ended due to a lack of work, even though it really didn't. They may have been discharged or they may have quit. So if we don't receive a protest from you, that claimant may continue to collect all 26 weeks of benefits because the claimant told us that they were laid off due to lack of work. So if the employer doesn't controvert that and protest the claim, we would never know that they may have been fired or they may have been discharged. Most claimants are honest, and they tell us the reason why their job ended, but not everybody. And sometimes there's even a disagreement as to how the job ended. A person might have taken it as a lack of work, but the employer really felt that they were fired. So if any reason that you feel a person should not be receiving unemployment benefits, Part 2 of the LO400 is the area is the form to send back to us and let us know. Once we see that protest come in, we're going to investigate that claim, and we're going to make a determination as to whether or not that person is eligible. The person may continue to receive benefits because we may not have known what the true reason was that they were separated from your employee. It could be very well, as I mentioned earlier, that they told us a lack of work, and we wouldn't have any other reason to think otherwise until we hear from you. And this is an example of Part 2 of the LO400, where this employer is indicating to us that the claimant was discharged for misconduct. There's also boxes to check if the claimant quit or if there was a strike or a lockout. Strike or lockouts don't usually affect school districts because of the Taylor law, but we do deal with industrial controversies in the private sector a lot. Just as a FYI, if there is a strike, there's a 7-week suspension before. If the strike isn't ended in 7 weeks, they may start receiving benefits then. If there is a lockout, they could be eligible beginning right away unless there's replacement workers. But there's a lot of things we look at with industrial controversies. But in this particular claim, the employer let us know that this claimant was discharged. When you return the LO400, at that point, you can also send us any evidence that you may have. If you had any warnings that were given to the claimant. If the claimant quit and they gave you a resignation letter, you could send us a copy of the resignation letter. As I said, any discipline that was previously done with the claimant, any warnings, maybe if it's an attendance problem, you could send us time records that shows that, the dates of absences or the dates of tardiness. Talking about attendance and misconduct, I just want to mention briefly, a lot of employers do get confused with attendance and when it rises to the level of misconduct. You could have a person that does have, quite an egregious attendance record. They've been warned. They've even been told, if you're absent again, that's unscheduled, we're going to have to part company. The problem is that no matter how bad their attendance record is, when they call in sick, unless you can prove that that person is not sick, which sometimes is difficult to do, it's not going to be considered misconduct because illness is a compelling reason to miss work. What some employers do, which is fine, if you have your doubts as to whether this person truly is sick or not, and their attendance is quite bad, you can ask them to produce a medical to verify their absences. Now, there are cases where a person who is on a mandatory medical, and we actually do that with our staff here, some staff that have attendance problems, their reaches a certain point, we're going to ask them to produce a medical every time they call in sick. If they don't produce that medical, that in and of itself could be considered misconduct. Not the fact that they were ill. Illness isn't misconduct unless you can prove they're not ill. But the fact that they were required to bring in a medical to substantiate the illness and they didn't do so, that could be misconduct. But a lot of employers, they get confused. Well, not confused, but the timing as to when to let somebody go is always the employer's choice. And sometimes it just comes down to the fact you just need to get rid of this person, and if they collect unemployment insurance, so be it. And I certainly understand that. But with attendance issues, same thing with tardiness. We've had cases where a claimant is habitually late. And if you're late after being warned and the employer did everything right, they followed progressive discipline, the person was warned, they were counseled, and then they were late again. If they're late because they oversleep, that's not a compelling reason, and that would be misconduct. But if they're late because maybe they take public transportation and on that day there was a verified problem with the trains, that could be considered compelling. So sometimes you may want to listen to what the reason was for their last absence or their last tardiness, because the Department of Labor, although we look at the claimant's entire employment record, we have to look at the precipitating incident. What was the last straw that caused the claimant to be discharged? And that's the incident that we really focus on. And that's why I'm saying it's important that if a person is ill, that you make sure that you can prove that he wasn't ill or they didn't produce a medical. Because if they do just say they're ill and you can't prove otherwise, it wouldn't be considered a misconduct. So in this particular LO400, the employer made us aware about it, aware of the situation that this person was discharged, so we're going to start looking into this right away. LO400 needs to be returned immediately only if there's changes to be made with the wages or if you feel the person shouldn't be paid. If the person was laid off due to lack of work and you knew about it and you have no problem with them collecting, that's fine. And then the LO400 is just for your records. You certainly don't have to return it as long as everything on it is accurate. And these are the numbers where you can fax the LO400s to. We did recently add an employer homepage to our website. In the future, we're looking at what we want to have as an employer secure landing page. I think that's being talked about being rolled out in 2013, which would be great. It would be a way for employers to correspond with the Department of Labor on a secure website electronically, and perhaps that would save a lot of phone calls and mailings back and forth, because what we need to do is when a person is discharged for possible misconduct, or they quit a job, or they refuse a job, we have to get both sides of the story. We have to call the claimant and we have to call the employer. Sometimes it's done by telephone. Sometimes we may mail a questionnaire. So employers who receive questionnaires from us, we usually give you 7 days to get them back to us. We don't adjudicate the case usually. We're mandated by the federal government to have 80% of our determinations done within 21 days. So, we're held to task on that by the Fed. So we do try to get determinations out as quickly as possible for that reason. Obviously, the people who lose their jobs most of the time are waiting on the money. They need the money, so we have to get determinations out as quickly as possible. If a claimant is found ineligible, it does at least gives them hearing rights. That if they disagree with that determination, they can appeal it to a higher authority, as well can the employer. And whoever is adversely affected has that right. We make all determinations, the Department of Labor. We make determinations with the best available information. As I stated, if asked, please give accurate and answer all the questions as well as you can. Good fact-finding equals good decisions. So we may ask for whatever evidence that you have, we may be asking for. And anything that you have that supports your case, please send it to us, because the more information we have, the more accurate our determinations can be. And just because we agreed with you and we issued a determination disqualifying the claimant, all of those facts are good, because if the claimant requests a hearing, the next level, you may have to appear at that hearing even though you weren't adversely affected. If a claimant requests a hearing, you the employer, should try to appear at that hearing, because otherwise anything in the file is considered hearsay, because you couldn't be cross-examined by the claimant or their attorney. So hearings are very important for the employer to show up at, even if they're the ones that weren't adversely affected by the determination. What's the use? Unemployment pays everyone, and that is statistically not true. Most people who file or who quit a job are found ineligible to receive unemployment benefits. They're disqualified. I think the figure is close to 80%. Misconduct determinations are maybe between 55 and 60%. Misconduct determinations, the burden of proof is usually on the employer, because they are the moving party. They were the person that made the decision to discharge the claimant. Voluntary quit cases, the burden of proof is normally on the claimant, because we consider the claimant to be the moving party. They initiated the separation. As I mentioned earlier, 80% of the claims have no issues, and they go through after a 1-week waiting week, then they start receiving their benefits. Claims with issues are paid when the issue is resolved, and the claimant is always advised in writing why benefits can or cannot be allowed. If you disagree, as I mentioned earlier, any party adversely affected has the right to a hearing, and the first level would be in front of an administrative law judge. Law judge decisions can be appealed to the New York State Unemployment Insurance Appeal Board, and there are cases that can be appealed further up the line. After the appeal board, it would go to the Appellate Division, 3rd Department, and the State Court of Appeals in New York State. There is one case in California that actually went all the way up to the Supreme Court, and that's the matter of Java. I believe the situation with that case was it dealt with an employer issue. An employer was found eligible by California Department of Labor. The employer appealed that determination, and at the time, California was stopping the claimant's benefits until the appeal process was finalized. The Supreme Court said, no, matter of Java, you can't do that. This program is designed, you have to pay benefits when due. So that was one case that actually did go to the Supreme Court, where now if the claimant was originally found eligible, they have to be continued to be paid until that determination is overruled by a higher authority. On this slide, I'm not going to go into a lot of detail on it. It's in an employer's handbook, and it talks about Section 581(1)(e, experience rating. Basically, what that means is what you, the employer, are being charged. The more people that are receiving unemployment benefits against your account, the higher your taxes are going to be, the higher you're going to pay into the system. Just to give you some basics, if you're the only employer in the claimant's base period, you're going to be on the hook for all 26 weeks of benefits. If there's other employment, the last employer is charged the first 7 weeks of benefits, and then weeks 8 through 26 are prorated between the last employer and any other employers in the base period. Many times when a claimant files, they only have one employer, and they would be on the hook for 26 weeks of the claim. However, there's a lot of claims that we look at where the claimant has many, many different employers in the base period, and so those charging sequences get a little bit more complicated. One of the things I did want to mention about Section 581(1)(e, if a claimant quits a job from you, and right after they quit, they file a claim, and we issue a disqualification, which I stated earlier, in order to break that disqualification, a claimant would have to go back to work and earn 5 times whatever their benefit rate was. If you, the employer, receive you get a copy of any determination that we sent to a claimant. So if that claimant ever broke the disqualification, they earned 5 times their benefit rate, and they refiled, you would never be charged on that claim, even though you're in the charging sequence, because of the fact that we sent you a determination that he quit without good cause. The problem for employers comes in when that person who quits doesn't file a claim, goes to work afterwards, and then files a claim if they get laid off. There's nothing we can do there because no determination that they quit your employee was ever mailed, and then they subsequently broke that determination. So there's really nothing we can do in those situations. And I certainly understand why employers get upset about that because of the fact this person quit their employee. If you still have work available at that point, you can always offer them that job, and then we would look at a refusal. However, the problem is many times you as the employer, you've already filled that position. The same applies whether a person quits a job or they were fired from a job. If you discharge them for misconduct, they filed a claim, and we disqualified them for misconduct, even if they subsequently break that disqualification and file another claim, you're not going to get charged because of the fact that we issued a misconduct determination with them. Basically, what's in our future, I mentioned the big thing that deals with employers, and that's the employer landing page that we're working on, which is going to be a secure website where you'll be able to correspond with the Department of Labor. And there's talk about not just the Department of Labor, but possibly other state agencies. So that's being worked on right now. We also are what we call a virtual contact center. I mentioned at the beginning of the presentation that there's really only 2 contact centers, one in Troy and one outside of Binghamton, New York. If a person calls to file a claim, it doesn't matter what contact center they get. They're going to get the next available agent. So if there's an agent in Glendale that's available to take that call, as the calls come in, they go into a queue, and they're distributed to the next available agent. So when a person calls, they never know whether they're going to get a Glendale agent or a Troy agent, but it really doesn't matter because you file a claim the same way. We also have an employer-dedicated line on our main numbers, so you can also choose that if you're an employer, and you can speak with someone who's actually manning that line. The Department of Labor actually stopped issuing unemployment insurance checks late in 2006. It saved the department a lot of money because you can only imagine the printing costs and the mailing costs when you're mailing out hundreds of thousands of checks each week.